Chairman.
Thank you, Senator Markey. Senator Wicker.
Dr. Jelinek, under EU policy, your board could have chosen the regulation route or the directive route. A regulation places a binding legal force throughout the continent. A directive would simply have had each country try to implement according to their own national laws. GDPR went the regulation route. The goal was and is to have one set of privacy rules that are interpreted in a uniform way throughout the continent. Why did you do that, and why was it important to have one data privacy policy instead of each member country having their own?
Thanks, Senator, for this question. The EU already had a data protection directive from 1995 on. And this data protection directive had to be set into the national laws of the 28 member states. So we had diversified laws, even if they had the same fundament. And during the last 20 years, the EU considered that it would be much more better to have one applicable law according for the whole continent, for the whole EU. And so it started in 2012 to negotiate the regulation. And the regulation was finalized in 2016 and entered into force and entered into application on the 25th of May, 2018, to have one continent, one law.
Okay, and with regard to how it's being implemented and how people have reacted to this, there have been reports that upon implementation, several companies shut down their operations, blocked access to European users, or required European consumers to pay for access to online content. Could you comment about that? Has that been overblown, or am I accurate in what I've stated there? And why would the companies have done so?
I can't contribute to why the companies have done that, but as far as I can tell you, is most of the companies on either side of the ocean, US companies and European companies, were preparing quite well for the entering into application of the GDPR. They had more than 2 years' time to prepare. The 25th of May was not the end of preparation. It was just the beginning of the common journey in the new field of data protection, because data protection was not that new, because as I just mentioned, we had already a directive from 1995 on, and the GDPR was no revolution, but just an evolution of the law that already existed.
Okay, let me ask Ms. O'Connor about this preemption idea. Ms. Moy suggested in her testimony that what we do here in Congress should establish a floor, not a ceiling. It seems to me that you feel the other way. So why should there be one? Is it your position that there should be one privacy standard for the entire country coming out of this Congress? And if so, why?
I think it's better for American consumers to know what the rules are, no matter what company they're dealing with in whatever country or state that company is based in. But I am not seeking a lower standard than we have. We would not seek weakening of existing laws. We would very much applaud the effort that was made in California and want to see strong protections. So, while I think it's too early to talk about preemption, I think one of your colleagues has suggested that the price of preemption would be very, very high.
Okay, why would a patchwork negatively affect consumers, though? That you alluded to that just now in your verbal answer, and it's in your written testimony too. How would it affect consumers adversely to deal with a patchwork from state to state?
I think there would be uncertainty and a lack of clarity about what the rules and guidelines are for each individual dealing with companies all over the country. And also, it does not get us standing in the global dialogue on data protection. Europe is leading the way, and other countries and regions are following a European model. I'd like to see the United States offer an alternative that has strong baseline protections, and I would agree with Ms. Moy that it's a floor, not a ceiling, but that would provide some leadership from Congress for all of the states, attorneys general, and the FTC to enforce.
Maybe you could supply on the record an example or two of how a consumer could be disadvantaged by a patchwork. We'll just ask you to do that on the record. Will you do that?
I will do.
Thank you, Mr. Chairman.
Thank you, Senator Wicker. Senator Blumenthal.